but again, it's called an interdiction. An interdiction is just like any other lawsuit. And so the person who no longer has capacity is going to have to be sued. So their spouse or one of their other loved ones is going to have to hire a lawyer. That lawyer is going to have to file a lawsuit. That lawsuit is going to be served on the person who doesn't have capacity by the sheriff's department. And they're going to have 15 days to answer that lawsuit. Now, if they don't answer within that time, which they're probably not going to because they probably don't know that they even got served with it, then the court is going to appoint another lawyer to make sure that their interests are protected. So you're going to have the lawyer that you have to hire, and then you're going to have the lawyer that the court appoints. The court is always also going to have to appoint a medical expert. And that's someone who's going to be able to examine the person and to make sure that they really need a guardian appointed for them. As you can tell, this can be a very time-consuming process. It can also be very expensive. You're going to have to pay your court costs. Sarah and I filed an interdiction proceeding a couple of weeks ago, and the court costs, not any legal fees, the court costs were $1,000. You're going to have to pay attorney's fees for not one, but for 2 attorneys. It's going to be humiliating. This lawsuit says that if the person can be brought to court, the law says if they can be brought to court, then the judge may require them to be there. A few years ago, I had an interdiction proceeding in Iberville Parish, and it was an elderly lady. She also was in the early stages of Alzheimer's, and she didn't know what was going on, but the judge required that she be brought into the courtroom. And so for her, it was a very, it was not something that she understood, and it was a humiliating process. In addition, there are going to be annual accountings required. You're going to have to hire someone or do those annual accountings yourself. I have Richard Mitchen here today, who's a CPA, so we may have to hire someone like him and have some additional costs. But the worst thing about an interdiction or a guardianship is that the decisions are going to be made by the person the court appoints and not by who you choose. So, as you can see, there are a lot of disadvantages to living probate. Now, you remember the story I just told you about the lady in Iberville Parish, elderly, they had to bring her to court? In that proceeding, there were people arguing over who should be her curator or her guardian. Here in Louisiana, we call a curator a guardian. Or we call a guardian a curator. I got that backwards. And so they were fighting over who that should be. And this proceeding went on for 3 years, from 2005 until from 2003 till about 2002 to 2005. And I'd like to tell you that in 2005 we resolved everything, but we didn't. And that year she passed away. And then we argued from 2005 until 2008 over who was going to get her money. So at the end, there wasn't nearly as much money left as there was in the beginning. Because in that particular case, we had 2 attorneys. We also had 2 CPAs, because they, one for each side, monitoring who was handling the money. And this was not, I'm sure, what this lady would have chosen at all. So you think there's probably got to be a better way to do this, right? And there is. So how do you avoid living probate, or how do you avoid a guardianship? Well, you need to make sure that you have some properly drafted and executed powers of attorney. First of all, you're going to need a property power of attorney or a financial power of attorney. A lot of times that will be referred to as a durable power of attorney. That's just a power of attorney that's going to appoint someone to take care of your finances if you can't do that for yourself. You also probably would like to have a healthcare power of attorney to appoint someone to make healthcare decisions for you if you can't make those decisions. I also like to have a HIPAA authorization. That's a document that says who has the right to get your protected healthcare information. If any of you have gone to the doctor recently, or you tried to get some information about your spouse or one of your children or anything else, they often won't give you that information because the law says they can't. They face a potential $25,000 fine per violation. So most healthcare providers will not provide any information to anyone other than the patient or someone that they have given written authorization to. And so it's very important that you have this HIPAA authorization to say who it is that is okay to have your protected healthcare information. Also, a lot of people want to have a living will. A lot of times people get confused with this. I hear this a lot in my practice. They confuse a living will with a regular will. A regular will takes care of your property. A living will tells your doctors and your healthcare providers that if you have an incurable injury or disease or an illness, or you're in a coma, and there's no chance that you're going to recover, that you don't want to be kept alive on artificial life support. So that's what a living will does. And again, that's not to be confused with a regular will. We're not actually going to take a break here because I'm talking a little faster than I normally do. So we're going to go ahead and talk about passing your legacy on. Does anybody know some ways that you might pass your property on at your death? Anybody? I know you know, Sarah, so you don't answer, okay? Anybody else have any other ideas about how you may pass your property at death? Anybody? A will, money, property, any of those things. A will is one way. The law. Through the operation of law. A trust. Those are all ways that you may pass your property on at death. And these are some common techniques that we often see. The spend it all technique. You all have all seen that sticker on the back of the car that says, "I'm spending my child's inheritance," right? Yes. A few weeks ago, I was driving down the road. There was this old beat-up car, and it had one in the back that said, "This is my child's inheritance." Now, you probably see the problem with the spend it all technique, right? We never know how long we're going to live. And so, to be able to time that last dollar with that last breath is going to be pretty difficult. For most people, one of their fears is that they're going to outlive their money. And so the spend it all technique is probably not a really good idea. So there's the do nothing technique. I think someone mentioned the operation of law to pass your property. And if you're choosing the do nothing technique, that's what you're doing. You're saying, I'm not going to decide who gets my property when I die. I'm going to let the state of Louisiana do that. Now, I had a professor in law school who said there's two things you never want to see made. One is sausage and the other's law. So that's particularly true when it comes to estate planning, because the law may not do what you want it to do. There are a lot of different scenarios, but I'm going to touch on just a few of the more common ones. If you are married and you have children and you pass away, you may think your property would go to your spouse, but that's not true here in Louisiana. Your property is going to go to your children. Your spouse is going to have a right to use that property, but they can't sell it, they can't mortgage it, or they can't do anything else with it without your children's consent. Now, most people don't want to go ask their children, is it okay if we sell the house that I've worked my whole life to pay for? And so, for married couples, the do-nothing technique often isn't what they want. For single people, if they have children, their property is going to pass to their children. If they don't have children, their property is going to go to their brothers and sisters. if their parents are living, their parents are going to have a right to use it, but the ownership is going to go to the brothers and sisters. Now, I have a lot of clients. In fact, Sarah and I met with one the other, not too many weeks ago. He had a brother that he had a falling out with, and he absolutely wanted to make sure that his property didn't go to his brother. And so the do-nothing technique is often not going to do what it is that you want it to do. So we talked about a couple of the common techniques for estate planning, the spend-it-all technique, the do-nothing technique, and how maybe those aren't the best that we can do. The other technique that I hear a lot is giving property away to your kids or putting their name on your bank account. Well, again, that can have some negative consequences. If you do that, if you just give your property to your children and they owe somebody some money, whoever they owe money to can come and seize that property and take it. So what you thought was going to be there to help take care of you may not be there. And so giving your property away to your children is probably not a very good idea either. Also, you can designate a beneficiary. A lot of you probably have retirement plans. Like I said earlier, your IRAs, your 401ks, those types of plans. Those do not pass through the probate process. They pass by a beneficiary designation. And so whenever you're doing estate planning, you want to make sure that you've got your will or your trust coordinated with what your beneficiary designations are. Also, as we talked about, you can sign a will, and we're going to talk a little more about that, or you can